coffee brewing as the sun peeks through the haze. And birds are chirping, serenading morning's praise. Front porch creaks as dreams fade away. America's awakened to a brand new day. Old vinyl spinning a sweet old tune. Day starts dancing under a sleepy moon. Loose print smudges on fingers of grace. America's awakened at her own steady pace. Sips of sunshine in a coffee cup. Simple moments lifting spirits up. From the mountains to the sandy shore. Morning in America, want just a little more. Neighbors waving with a friendly rise. Kids with backpacks chasing daylight skies. Eyes cooling on a windowsill so fine. America's awakened with a heart full of shine. Old vinyl spinning a sweet old tune. Day starts dancing under a sleepy moon. Newsprint smudges on fingers of grace. America's awakened at her own steady pace. Sips of sunshine in a coffee cup. Simple moments lifting spirits up. From the mountains to the sandy shore. Morning in America, want just a little more. Neighbors waving with a friendly rise. Kids with backpacks chasing daylight skies. Eyes cooling on a windowsill so fine. America's awakened with a heart full of shine. Neighbors waving with a friendly rise. Kids with backpacks chasing daylight skies. Eyes cooling on a windowsill so fine. America's awakened with a heart full of shine. Tractors rumble, fields coming alive. Big wheels turning where hopes and dreams strive. Laughter echoes down the old dirt road. America's awakened to lighten her load. America's awakened to lighten her load.
Good morning, everyone. I hope you're all doing well. uh, for those of you watching and you're saying that the date is wrong, I know I forgot to change it, and I can only change certain ones. So on YouTube, I have it corrected now, but it's going to be wrong on Twitter, and it's going to be wrong on Rumble. So I apologize. If it'll let me correct it later, I will. That was my bad. Can you guys hear me okay? You guys got me? I forgot to check. It says I have the correct. Do I sound far away? It shouldn't. Let's see. We've got Max Lab in here. Oh, it's his birthday. Happy birthday. Happy birthday, Max Lab. Georgie's in first. Star Z, good morning. Paul, good morning. Really enjoyed talking with Paul the other night. When I finally can like interact with you guys, I can see and hear you. It changes like how I view you, because sometimes like I love seeing your names and stuff, but it doesn't give me any idea of who you are. You bring that to the show, but then I kind of pick up some of the stuff. Good. So I know Georgie already did this on her show last night, but there's a new motion. I was not able to watch. I was not able to do that much last night. I was taking care of some other stuff, but there's a new motion, and I'm trying to see. I thought I had it. Where is it? And I'll read it. Oh, okay, yeah, I do have it. Max Lab, MaxLab always sends me. He's all on top of this stuff, and will be like, "Hey, here's this." So I know I can always, if I don't have it, I can always go to where MaxLab has sent it to me, and I do appreciate MaxLab. Thank you again. So this is here. I'll share it here. There we go. No, I still want us to be. There we go. Actually, maybe I can do it like this. No, sorry, I'm playing around with it. Okay, I'll do it like this. It's not the best view, but well, actually, here, I'll do this. And Georgie, Coop, you guys have the thing if you guys want to come in. So, report of 7B conference and related efforts to narrow issues and response to plaintiff's motion to compel. Uh, Upon issuance of the order to hold a live phone conference, the conference was scheduled for 9 at 10 a.m. Counsel conferred on the phone for 90 minutes. Until that conference, the defendants did not understand many of the plaintiff's requests, given their vagueness and confusing language. That some called for information in the nature of interrogatives, er, er, yeah, interrogatives, and some were too unspecific and overbroad to be able to determine what was being requested, making meaningful responses problematic. Okay, yeah, sure. Um, sure. I do want to move this if I can. I don't like this. Oh, it's not going to let me move it in this. I don't like it on the bottom, but whatever. I'll deal with it. um, Following the conference, the defendants provided responses to 17 of the plaintiff's 20 document requests. Some responses were provided, notwithstanding objections. The unresolved objections remain to request number 5, 11, and 12. Following the conference on January 12th, the undersigned emailed the plaintiff's counsel. To further narrow the issues, it has been your client's practice to show on YouTube any and all private communications of my client that he has obtained from any source. Are you willing to stipulate that any private communications, phone numbers, other non-public information we provide will not be shown or read publicly on YouTube or shared with any third parties? If you will stipulate, I can determine our position in light of that stipulation. The plaintiff's counsel responded, I will never stipulate to anything that has no basis in the jurisprudence of the world. Please stop acting like you're not an attorney. On January 20th, in a final effort, resolved the remaining issues on the motion to compel, the undersigned emailed the plaintiff's counsel that objections were being dropped to 2, 3, 4, 6, 8, 11, 14, 15, 16, 17, 18, and 19, and explaining the remaining issues with the other requests. The email concluded, I am available Monday after 10 a.m. and Tuesday until noon for a phone call if necessary. If you would respond by email indicating any agreements, we can plan a call to discuss the remaining issues. No response was received. Um, Amended discovery responses were served January 21st, maintaining objections to only 3 requests, which are addressed here. B. Remaining unresolved document requests and objections. 5. Uh, RFP number 5. All phone records sufficient to show all phone numbers and providers you used during the relevant time period, and all documents, including mobile phone billing records showing the calls you made or received during the relevant time period relating to the allegations in the complaint or in plaintiff's response in opposition to your motion for summary judgment, excluding all exhibits attached thereto. Objections. This request is not reasonably or narrowly tailored to seek discoverable relevant evidence, but is designed to place the defendants in unreasonable burden and is classic fishing expedition for evidence in support of claims, Porter v. Ray. While discovery is broad, parties may not engage in a fishing expedition to obtain evidence to support their claims and defenses. Um, how is a call log a fishing expedition? I don't. How can the defendants know if a call related to the allegations in the complaint from a call log? Uh, really? We've seen phone calls to the sheriff. People want me to zoom in. Okay. Um, um, knowing much of the individual calls related to the request to impose on the defendants a burden of going through phone call logs since January 1, 2020, and somehow knowing which individual calls related to the allegation were related to the allegations in this case, which is impossible. Well, I don't think they're saying. Did they say related? No, during the relevant all mobile filling, they're not asking for, hey, go through and find specific ones. They're just saying give us all the call logs during this time frame. So interesting. Uh, Even if just providing the phone logs without identifying specific entries as relating to the allegations, this request would divulge every single phone call the defendants made or received, which would enable the plaintiff to call any number to determine whom it belongs to and ask whoever answers on the phone, answers on the other end, whatever he wants about the defendants to use for whatever purposes he wants, such as YouTube content. This is a license for him to invade the defendant's privacy and to use whatever information he finds out for whatever purposes he wishes. Guess what? Yeah, that's exactly what it's for. Because again, the lawyers have, like, they already have a basis. They're going to build more of a case. There is no reasonable expectation of discovery any admissible evidence, nor is the request narrowly tailored for that purpose. Really? Hey, give us a copy of your phone logs. That's not narrowly tailored. They're not saying give us a copy of everyone you talk to. Like, this is pretty common. Um, the burden of this evidence outweighs any benefit because the plaintiff cannot explain what relevant evidence he expects to discover through this request. The defendants further object because the plaintiff's current complaint and the summary judgment opposition collectively contains the totality of alleged statements. So, okay, this is kind of interesting. So, he is he's talking about the summary judgment opposition. This is why I've told you guys, do not get wrapped around the axle about these motions. They determine how they will determine how the thing goes. So here he's got an objection and he's basing it off of another motion. Now, depending on how this goes, which is, as the judge has already said, is likely to be denied, their opposition, uh like, yeah, he's going to call to that and say, oh, well, they previously argued this. um so if the motion were upheld, it's normally a stronger thing, but if it's denied, uh unless if what he's arguing here relies fully upon that, um that could it could hurt the way he goes forward. It could hurt the way Randy goes forward. So it's very interesting. Um, Now I do expect that summary judgment. I expect that to be denied. The judge has already indicated that. Just so you know, I'd have to look at the opposition that they filed to look at that. AVA's in here. Welcome. Um, He uses the same wording, spins it 5 ways. Well, yeah, yeah, but it's always for YouTube content. And as we've seen, the argument of it's for YouTube content has not really done well with this judge. Uh, and again, if that's what he's going to rely on, the judge is just going to say, okay, you can't, that would be, this is where like gag orders come in. Hey, you can't show this. But, you know, telling Jeremy you can't show this. It's a gag order. It's temporary. It's limited in scope, which could actually be very easily upheld. But it doesn't stop like that. That's still going to get the motion granted. That's where a lot of his arguments are kind of stupid of using YouTube. Um, I feel he's trying to get the summary. Well, if there's a summary judgment, there won't be a jury. A summary judgment means the judge is going to be like, yeah, there's no claim here. This is dismissed. That's what that's why he applied for a summary judgment. um, collectively contain the totality of alleged statements by the defendant for which the plaintiff claims A. Defamation, B. Extortion, claims to be dismissed, and C. Tortious interference. If there are any actionable, there would be no need for him to invade the defendant's private communications in search of evidence. This right here is going to be a problem because they're going to say, look, this is just a call log. This is no you're not invading their private communications. If we talk with the other person and they want to give evidence, that's not an invasion. That's someone giving the court evidence, and that all can be done in separate affidavits and depositions to where. If the court wants to put a gag order on them and say, okay, just let's see what they have to say, they can do that. There is no apparent connection to any of these claims or the factual allegations underlying them with the request for all communications relating to the plaintiff since January 1st, 2020. Actually, there is third-party communication and her calling the sheriff every effing time. Nothing the plaintiff can discover in the private communications will magically change the non-actionable statements identified in the complaint and the summary judgment opposition into actionable ones. Rather, this request is a classic fishing expedition. While discovery is not broad, parties may not engage in a fishing episode. Okay, yeah, we've already seen where he put that. I'm just sorry, I was just looking to see if there's a footnote. The defendants further object because, as a public figure, the plaintiff is not entitled to insert into a court document a hodgepodge of statements he finds offensive or critical to him. Okay, this is a defamation case. but which are not remotely actionable by a public figure. Cram them into an attenuated legal claim and then use that as justification to invade private lives and communications in search of who knows what for his who knows how. Although his regular practice is to make YouTube content, doxing private communications involving the defendants that he procures from any source. Yeah, this paragraph is a very weak argument. This is a defamation case. Like literally statements he finds offensive or critical of him, like they are at the heart of this case. What do you want to bet when the judge makes this thing? He cites to this paragraph right here. The defendants further object because the plaintiff's purpose for this request is to burden the defendants and the plaintiff's intent and motive to abuse and exploit litigation for ulterior purposes was admitted by him publicly. A lawsuit isn't to win a lawsuit. It is to make you spend all your money on a lawyer and bankrupt you. That's what the win is. I could care less if I win in court. If I win in court situation, my goal is to make sure you have no money. That is the goal of the lawsuit. Well, okay, that's all well and good, but again, uh, the this is what's going to be at the heart of the motion for summary judgment. This right here. Number 11, RFP number 11. Documents sufficient to show the number of online views and or impressions of any posts on any of your social media accounts, including but not limited to YouTube accounts, Rumble accounts, Twitter accounts, and Facebook accounts during the relevant time period. The defendants object because the request placed the defendants the burden of screenshotting every post since January 1, 2020. No, it doesn't. No, it doesn't. From all of these apps without specifying a single post that, for example, constitutes defamation, extortion, interference, or anything related to the claims in this case. He's not asking for posts. He's asking for the number of online views or impressions. Okay, this goes. Now, this one right here, number 11, I'm gonna make a prediction. This one goes down hardcore, hardcore. And here's what Randy Shockett is gonna say. Hey, the plaintiffs has already argued, as it applied to the signs. Hey, you can't prove anyone didn't see him except for these three people. And he's already argued that because no one saw them, that means no that my client doesn't have a claim. So we're not asking for the posts. We're asking for the views and impressions to show that people actually saw these. Yeah, again, don't worry about the motions. Don't worry about what's denied, what's allowed. Don't focus on that. Focus on what they're saying. This is like this is, right here is Bruce undermining what he argued in the deposition. So in the deposition, he was trying to build a case that, well, no one saw this, so there was no damage. Okay, now they're showing posts that are also defamatory and want to show that no, people saw these. People absolutely saw these, so there is damage. So depending on how this motion goes, that'll show you like how a lot like how what Bruce is going to be able to argue later on is what this is going to do. Melissa Joy said the weather needs to get hotter. Absolutely. I hear it's really cold down there. People were sending me, my friend in Biloxi sent me a picture of a snow covered beach. There's no requirement for the defendants to create documents that do not exist in order to respond to discovery requests. Actually, you can just go to Facebook, you can go to YouTube, Rumble, Twitter, Facebook, and you can get a what's it? It's a thing of your account to show like where like I've seen it there. I forget the website, but I've seen one where it shows my account, how many subscribers I have, when did they come? It shows a little graph. How many views do I have? When did the views come? Like you can get this stuff. They don't have to create anything. And here's the thing: if they don't give this, Randy will be like, okay, well, we can get it from other sources, and then just make them look stupid in front of the judge. They didn't provide it. Uh, it, in many cases, and I've seen people fight with discovery in court. Most cases, you're always better off just providing the discovery and then arguing about it later. This request is not reasonably or narrowly tailored to seek discoverable relevant evidence, but is designed to place the defendant in an unreasonable burden and time consumption that is classic fishing expedition. Okay, so he's relying on the same things as before. While discovery is broad, parties may not engage in a fishing expedition to obtain evidence to support their claims of defense. This isn't a fishing. He's asking, what are they going to get by finding out how many views you have? See, here's the real problem. Here's what this is. This one for sure is going to be um, overruled. This objection. The judge is going to say, no, I want to see those views. Absolutely going to want to see those views. And here's where John and Lynette, this is where they've undermined themselves. They have created other accounts. And if you don't think Jeremy knows about it, oh, he knows. So when the judge says, no, you have to do this, and they give it for their main accounts, they're going to forget to give it for their alternate accounts. And Jeremy knows that. And Randy Shockett knows that. And there are going to be people out there saying, oh, you're giving up the strategy. No, the strategy is already in play. It's already in play. That like I'm not revealing anything. Like Jeremy is painting them into a corner. And if they give up all the alts, that also is good for Jeremy, because here's the thing, those alts, they definitely broke the law with those alts. That's why you would have an alt, is because you think you're stupid and think you're anonymous. That's why when people come at me on Facebook, that's why I don't post anonymously. Like everything I post is up. Do I have alt accounts? Yeah, but if you wanted the post from them, you're not going to get anything from them. Like on Twitter, I've got alt accounts. Most of them, here's why I have them. When someone blocks me, so I can still read what they're saying about me. That's why I have so I can see. And yeah, I admit I've got alt accounts. I don't post with them. Or if I do post, it's stupid posts that have nothing to do with someone else. And it's because I've had to prepare for legal stuff. And people need to pay attention to this case. All these people posting on Facebook and Discord and other places, pay attention to this case. Like this is actually a really good case about how to operate online. And we've seen that here in the last couple days. Don't go onto platforms with accusations without any proof. Are you stupid? Have you not watched what happened? I saw someone the last time the golf course got snow was in 1958. Yeah, please hit the like button. I appreciate it. Okay, Max Lab. I might get to them. I might not. The snow can stay away. Last time snow was in Tampa in 1977. Yeah, the blizzard of 77. My family remembers it. I wasn't alive. Um, um, the request is not reasonably okay. It's a fishing expedition. The defendant for evidence. The defendant always burden. Okay, we did read that one. Number 12, mobile phone records sufficient to show all phone number and providers you used between 1 January 2021 to date and all documents including mobile phone record billing records showing the calls you made or received between January 1st, 2021 to date relating to the plaintiff by name or otherwise. This one, I could see where the judge might say that these dates are overly broad, and might say no. But I know why Jeremy is using them, and what they're probably going to come back with is, hey, she's told people that that Jeremy, they were there and didn't follow Jeremy, and that is a basis to this case is that they followed him, and we've made that in our complaint, and they were buying the property in 2021. So yeah, we've asked for records leading up to and including that purchase. So I can see where this one will likely, I mean, just on its face, prima facie will likely be overruled. But let's read on. This request is not reasonably or narrowly tailored to seek discoverable relevant evidence, but designed to place a defendant an unreasonable burden. It's tailored January 1st to today, like 4 years of records. It's and just send us your phone bills for 4 years. Like I had to in my divorce, I had to provide almost 10 years of records. Really? And you don't think a defamation case? Like, oh my god. But I'm not gonna say he's like I will say this. Bruce is smart for arguing a lot of these things. I just don't think he'll be completely successful. Definitely on these last two, I don't see where he'll be successful. That's my prediction. I could be wrong. I could be wrong. That's why we're talking about this. Um, how can the defendants know if a call related to the plaintiff from a call log? Well, it doesn't have to be related to the plaintiff. It could be related to the case. This request would impose on the defense a burden of going through phone call logs since January 1, 2020. No, okay, got the date wrong there. And somehow knowing which individual calls related to the plaintiff in this case, which is impossible. Even if just providing the phone logs without identifying specific entries as relating to the plaintiff, this request would divulge every single phone call the defendants made or received, which would enable the plaintiff to call any number. Okay, yeah, of course. Of course. That's the point. Determine who belongs. Yeah. This is a license for him to invade the defendant's privacy and use whatever information he finds. Call logs are private. They're used in cases all the time. And this is a defamation case. Okay? So normally when lawyers do these, they start with their best argument and then the arguments get weaker the more they go down. So if he has designed it this way, it, like on the especially in these last two, he's not doing a very good job. But these are well, I don't think his because this is number 11, so I don't think his like I don't, these are he's doing these in numerical order, so they're definitely not in strongest to least strongest. There's no reasonable expectation of discovering any admissible evidence, nor is the request narrowly tailored for that purpose. It is narrowly tailored. You're not asking for a summary of every phone call. You're just saying we want to see phone call logs. We're not even asking who is that person to. We'll find it out. We'll find out who they called. But you're not asking what were these phone calls about. That would be not narrowly tailored. Now you can ask the phone logs and then go through and start asking specific information, but you can't say, "Oh, we want to know what every phone call log is about." That would be not be narrowly tailored. Um, Defendants further object to because the plaintiff's current complaint and summary judgment option collectively contains. So he's basing it again on the summary judgment option or opposition. Sorry, collectively contains totality of alleged statements which claims a defamation, extortion, tortious interference. If they've already been dismissed, so I don't know why he's putting it there. But unless if he wrote this beforehand, it's neither here nor there. If any are actionable, there will be no need for him to invade the defendant's private communications in search of evidence. He's not invading the communications; he's just asking for a log. They're like you're not actually listening to the communications. There's no apparent connection to any of these claims or the factual allegations underlying them. Yeah, now she it's in his complaint that no, she followed them, so that's what they're establishing. Relating to the plaintiff since he screwed up on the date again. So is it January 1st, 2021 or is it January 1st, 2020? For any time period or for any time period. Oh, Bruce. Bruce. Ooh. Yeah. You're saying they're not narrowly tailored? He could say, no, we should. His best thing would be, no, should only do them since May of 2023 when the cease and desist. Ooh, I think this right here is a mistake. Like, to object and get everything thrown out, yeah, you can do that, but he knows that this is not a strong argument, and what he should be doing is saying these are not narrowly tailored enough. Uh, say we would not object from this date to this date, because then the judge would be like, okay, yeah, I'll sustain that objection. Yeah, we'll go with it for just these dates. Like this is a strategic mistake, in my opinion. Unless if he's expecting this to get denied and then is going to come back with a new objection and say, okay, well, how about that's the only way I could see this being strong on him. Nothing the plaintiff can discover in private communications. They're not private communications. They're just a log. Well, imagine like if you were asking for emails during that time frame, yeah, that would be private communications. A log is just a log. Will magically change the non-actionable statements. Rather, this request is a classic fishing expedition. The defendants further object because as a public figure, the plaintiff is not entitled to insert into a cart deck. Okay, Hodge, we've seen this before. Again, this is a defamation case. This is going to no. Defendants further object because the plaintiff's purpose for this is to burden the defendants. If we've seen that one, okay. So, is this going to be just a rehash? Parties may obtain. Oh, he finally read the rules, federal rule of civil procedure. Really? May obtain discovery upon regarding any non-related matters. The court considers several factors. relevant to information, the party resources, importance of the discovery, and resolving the issues, whether the burden of expense of the proposed discovery outweighs its likely benefit, information within the scope of discovery. Notably, although the scope of discovery is broad, the discovery does not permit. Okay, parties served with discovery are generally not required to create documents in order to respond to such discovery. Since Rule 34 of the Federal Rules of Civil Procedure. Okay. Noting that a party cannot produce documents that do not exist. Yeah, these all of these documents exist. Like literally, you can go get them. Yeah, it's up to the defense to prove they didn't do what the plaintiff claims. Yeah. Noting that the parties are not required to create new documents to respond to discovery requests. Rule 34 limits a request for production to documents which are in the opposing party's possession, custody, or control, and does not require to create new documents for production. Again, if they don't give this stuff, most of it, Jeremy can, okay, well then we're gonna subpoena the phone records, but your client then has to let us know what companies they had, what phone numbers they had, so that these places can comply with the subpoena. That'll be the next thing if they don't produce these. And of course, he's going to object to the subpoena. But again, because of this, this is why I say don't get hung up on the motions. If this motion is sustained, these objections are sustained, and they say, okay, we're going to go get them elsewhere because of what he claims here is that they're asking for documents in existence, and then Jeremy is like, okay, I'm going to go to Verizon. Okay, you have to give me every phone number that you've had. They'll be able to get those, and when he objects to that, oh no, we're not going to give that stuff up because of this, and this. Your Honor, they already said they weren't going to produce this, so we're trying to get this. They're saying that these don't exist with them, so we're going to go get them from somewhere else. Don't 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 think when a motion is upheld or denied that's a win. It just determines what path you go down. Okay, fishing expedition. Plaintiffs request 5 and 12 both seek 5 years of the defendant's phone call record showing calls you made received during the relevant time period related to the allegations and showing calls you made or received. Absent showing a good cause, voicemails, mobile phones, and tablets are not deemed necessarily accessible and need to be searched or collected from in response to a summary request. Okay, this is another way. Requesting party must show good cause to compel discovery electronically stored information from sources and the producing party no, he's just asking for phone records. But if you deny them, he could actually then say, okay, we want to subpoena those devices and have someone pull everything down from those devices. Again, don't get hung up on these motions. It determines what path you go down. Plaintiff, and again, they will, if the judge says, okay, yeah, you don't have to provide them, their subpoena is going to rely on this motion to get that stuff. And, oh, Jeremy won. Lynette won. It's a motion. You're stupid if you're arguing that. You are stupid. Yes, please. If you guys can, please give to Uncle Frank's family, and they've been under attack under recent days. So please give money to them, because we're trying to help them honor Frank's memory, and people are trying to stop that. It's under attack. Please put the link in there, mods, if you would. Bruce just admitted they don't have evidence because they got rid of the devices. That could be. And if the judge says, okay, yeah, I'll see your motion, and then they say, okay, we're going to subpoena these devices, and then they say, oh, well, we don't have the devices, then it reopens this motion. See, it just determines what path you go down. It does not mean it's a win or a loss. Plaintiff does not have a generalized right to rummage at will through information that the defendants have limited from public view. Again, That's not what a call log is. Holding that the plaintiff does not produce information from social networking account that is irrelevant, as defendant is no more entitled to such unfettered access to plaintiff's personal email. Okay, than it is to rummage through just. It would be impossible for the defendants to look at a list of 5 years of dates, times, phone numbers for all phone and every number call received. That's not what they're asking for. They're asking for a log and check off the ones related. Um, they're saying, no. This will be the argument if this goes in front of the judge. Your Honor, we're not asking them to do that. We're asking for a phone log. We'll go through every single one and figure out which ones are related. They're giving Randy some good arguments. Of course, since records of all phone call are requested, any relating to the plaintiff or his claims would be contained on the call logs. Other than the plaintiff planning to begin calling numbers and asking whoever, did you speak? Yeah, they can do that. There appears to be no possible relevance to these requests. This is okay. I'm going to say this right now. This is a stupid motion. Bruce should just give this stuff up because, again, this is a defamation case. So this would be relevant. This would be relevant to that. Oh my God. The plaintiff has not explained what evidence he believes. Well, Your Honor, we don't even know. We haven't seen the evidence relevant to proving the claims in this lawsuit. If any of the defendant's comments cited by the plaintiff complaint in a summary motion were actionable, everything is hinging. He's saying that everything now of this, he's now hinging upon that the summary judgment. So if the judge says, "Yeah, I'm not giving a summary judgment," that means they're actionable. There would be no need for him to invade the. Yeah, okay. So you've just hinged it upon that. That is stupid. So stupid. So now Randy can say, Your Honor, you're accepting our opposition to summary judgment. That alone means these are actionable. So all of these requests need to be held. Oh my God, so stupid. There's no that's a big risk. You're putting it all on that. Whew. There's no apparent connection to any of the plaintiff's claims in the lawsuit or factual evidence. Nothing the plaintiff can discover in private communications will magically change the non-actionable statements identified in the complaint and summary of judgment opposition to the actionable ones. Rather, these requests are a classic fishing expedition. Finally, the burden to the defendants outweighs the benefit should they be asked to procure the phone logs they don't currently possess, but because as already noted, there's no legitimate expectation that if they don't have them, you can subpoena them from the who were you with? Oh, I was with Verizon. Okay, we're going to subpoena Verizon. That will lead to the discovery of evidence. In determining proportionality, the court considers several factors, including the importance of the issues at stake in the action and the amount of controversy. So, right here, Randy can say, no, we already know that there's evidence there because they said they moved before Jeremy. So, we know who their realtor was. We want to look at the phone call logs and when they were contacting their realtor because that would show if they followed Jeremy or not. That's all relevant. And anyone else that they would have had to contact in the matter of what's that? Buying a house or the land. The parties' resource and the importance in the discovery and resolving the issues with the burden or expense of this outweighs the benefit. There's no real expense here. You just go pull up your old bills. Shut up. Requires creating documents that do not exist. Phone bills don't exist? Really? I get a phone bill. It tells me everyone I called. Plaintiff wants to learn how many views there are for each and every social media post. He doesn't explain how this information is supposed to be provided without creating non-existing evidence. Now, they exist, and you've already laid the groundwork for that. Again, the path. As the objection states, this would require defense to screenshot every single. No, it doesn't. For all these apps, so the plaintiff could see them and view numbers, but there is no requirement for the defendants to create documents that do not exist in order to respond to discovery requests. Given any lack of connection to this request, to any of the claims of the lawsuit, the burden of the request outweighs any expected benefit. Plus, the complaint is capable of himself of finding the defendant's post as he testified in December 2nd deposition that he canvassed social media posts. Oh, but all accounts. He can argue, hey, those were only for certain accounts. We need to see all accounts because there was defamation on this account. We can reasonably assume there's defamation on all accounts. Absolutely, Paul. Absolutely, Paul. Uncle Frank's family is doing a great thing. Give him a couple bucks, share that out. I do have to get going on this. Found that narrowed requests seeking plaintiff's bank phone checks, social media, email records still appear to be broad categories of personal records that are irrelevant and disproportionate to the needs of the case. Okay, so is this case right here a defamation case? Cornelius v. Rollins Ranches? Is that a defamation case? Because I guarantee you there are defamation cases that asked for all of this, and they're not asking for bank records. So this tells me it's likely not a social media case or a defamation case. The magistration judge entered an order defying defendant's requests. Okay, that may or may not be held. I don't know. Similar in the present case, 11 is not proportionate to the needs of the case and does not warrant burden the defendants to be placed in order to respond, creating non-existing documents. Okay, just repeating. The undersigned made strenuous efforts to resolve the plaintiff's document request and the defendant's objections. The remaining unresolved objections should be sustained for the reasons stated herein. Okay. So there we go. That's it. I do have to get going on with my day. I do thank you all for being here. I might be on later. I don't know. I had some important phone calls last night. They might turn into important phone calls today. We'll see what I can do later. Make sure you guys check out Georgie and Coop. They're on at 8, so 45 minutes. So they'll be on in a little bit. And we see Mama Coop. I see Yoda in here. I don't know if Mama Coop is in here, but Georgie's in here. So check them out. Give to Uncle Frank. Share if you can't give. Share if you can't give. And I really do appreciate it. Also, check out Minnesota Black Robe Regiment. Watch the Freedom Flock. Help out TC. I think we're doing our show again this weekend. Doing it live on Sunday. So we're getting back into a flow with that. And beyond that, again, all of you, thank you for being worth serving.
Coffee brewing as the sun peeks through the haze. Birds are chirping, serenading morning's praise. Front porch creaks as dreams fade away. America's awakened to a brand new day. Old vinyl spinning a sweet old tune. Day starts dancing under a sleepy moon. Loose print smudges on fingers of grace. America's awakened at her own steady pace. Sips of sunshine in a coffee cup. Simple moments lifting spirits up. From the mountains to the sandy shore. Morning in America, want just a little more. Neighbors waving with a friendly rise. Kids with backpacks chasing daylight skies. Eyes cooling on a windowsill so fine. America's awakened with a heart full of shine. Old vinyl spinning a sweet old tune. Day starts dancing under a sleepy moon. Newsprint smudges on fingers of grace. America's awakened at her own steady pace. Sips of sunshine in a coffee cup. Simple moments lifting spirits up. From the mountains to the sandy shore. Morning in America, wanting just a little more. Neighbors waving with a friendly rise. Kids with backpacks chasing daylight skies. Eyes cooling on a windowsill so fine. America's awakened with a heart full of shine. Neighbors waving with a friendly rise. Kids with backpacks chasing daylight skies. Eyes cooling on a windowsill so fine. America's awakened with a heart full of shine. Tractors rumble, fields coming alive. Big wheels turning where hopes and dreams strive. Laughter echoes down the old dirt road. America's awakened to lighten her load. America's awakened to lighten her load.